I can think of some instances where we have people come in and ask for a special exception and a variance, recognizing the board may not find that it suits a special exception for whatever reason, but as the fallback, there's a variance opportunity as well.
Look, I still want my elected officials to make the decision, not an appointed official.
Well, no, and that's a fair assessment, and it goes both ways. Some municipalities, I can think of a handful, rather have the zoning hearing board where you can put maybe more expertise, engineers or what have you on the board. Some want the elected officials to do it. So I get your argument either way.
One of the problems that we talked about with the zoning hearing board as opposed to the Board of Supervisors is the Board of Supervisors can't have any alternates. The zoning hearing board can have 3 alternates. And I've just seen this happen in Mount Pleasant Township. If somebody has a conflict on the Board of Supervisors, there's nobody to step in. But on the zoning hearing board, if somebody has a financial conflict, some sort of a legal conflict, somebody else can step in and serve for that hearing on that board. That was one of the considerations, just the flexibility of the board. The process should be a lot quicker too from the zoning hearing.
And other drillers wanted that. They wanted to go right to the zoning hearing board versus to the elected body. But remember too, the elected body faces the electorate. The zoning hearing board doesn't.
But who appoints those positions?
The supervisors.
That's right.
Yeah.
So that's the majority of the supervisors.
But their appointments run,
Different terms, so they don't all end together.
the Board of Supervisors can't get rid of the zoning hearing board just because a new board comes in. So the members that are there now are staggered. They can only replace as they come up unless, well, if a member of the zoning board commits like a malfeasance, like, you know, they steal money or something, they can be removed. But they can't be removed without cause just because there's a new old board.
Now, I don't know how many, I haven't seen a zoning hearing board a lot. Do you know how many alternates we have? And I don't know, but it's under Pennsylvania law, it's how they stagger their terms.
You can have 3 alternates on the zoning hearing.
How often are they used? How often are the alternates used?
Well, the alternates usually participate in the actual hearing, but they may ask questions. They usually just don't vote. And they're used based on somebody's absence, there's a lack of a quorum, or a conflict of interest. So it's just a recognition that they may never vote. We've had them boards, I've never seen an alternate vote. And I've had boards where the alternate seems to vote all the time. You know, but you have that flexibility because you could have up to 6 total members, 3 members and 3 alternates. And with a township this small, the odds of you bumping into somebody that might have a financial interest in an application exists. It's not, you know, the 15,000 member township. You've got, you know, several hundred people or bigger landowners, and that's how that came about.
Any other public comment?
Yes, Brian.
I know you had mentioned you're aware of 2 pads in the township that aren't located within the overlay district. You said you wouldn't have an issue with that. Procedurally, we don't want to get into a catch-21 when we come in and you're saying you're an existing non-conforming use, you can't expand a non-conforming use with those pads that are already there, because both of those pads are laid out for more wells that could be drilled.
Yeah, there's obviously by law natural expansion of a non-conforming use. If there's some language that we could put into there, into that particular district.
Could you specifically for us, not tonight?
Yeah, I mean, on the letter and the exhibits that we
made.
I mean, we could even give you, the engineered plans of those pads so that they're included within the overlay district. We just don't want to, this board leaves, the new board comes in. We don't want to get into a position where we got pads that are already there, more wells go in, and now we're stuck because we're already
Understood.
If you could give us a very specific location of those pads.
I have to say that, I mean, that goes to the very heart of spot, unconstitutional spot zoning. It does. I mean, that you show us here where you want your pads, and we'll just do it. I mean, there has to be a planning basis for the creation of the zoning.
The problem, Mr. Gallagher, with the Marcellus drilling is this. It's unlike any other type of zoning use anywhere that I've seen. It wants to go everywhere. The traditional zoning does not allow that type of use everywhere. So we had to find a way to accommodate. When somebody talks about our current zoning ordinance, allowing it as conditional use in every district, That's true. The problem with that is that ordinance was written for shallow wells. And those shallow wells take up about a 50-foot diameter compared to a Marcellus pad, which is what, 5 or 6 acres? The impact is completely different. So when that ordinance was written years ago, they weren't thinking that somebody was going to come in and put a 5 or 6 acre pad. That was for shallow wells drilling.
I don't dispute any of that, Mr. Earl.
And I think that anybody can make an argument for the fact that, yes, you can put a shallow conventional well in almost any zoning district because it's low impact. But the problem that we have as a Board of Supervisors is we have to find a way to accommodate everybody in the township so they can get drilled. The overlay district was the most logical way to do it. We put the areas that you requested to drill in a year ago, we included those in there, and we tried to expand them a little bit so that if you needed to move your pads, you had room to do it. That's why they seem to cross lines a little bit, but that's why those areas were incorporated. We're just trying to accommodate them.
And my point is, I believe that's subject to exclusion.
And I don't
believe there's any rational planning purpose for the creation.
And I just explained that in order to fit it in everywhere in the community, we had no other way of doing that. And I have no objection to Mr. Temple wanting to put those actual pads on that overlay so that he's protecting the future. But we've also run into the issue where a driller will say, well, this is where we want to put the pad. And then 6 months or a year later, no, we want to go over here. So in that situation, what do we do as elected officials? Do we say, okay, do anything you want anywhere you want in any zoning district in the township? You see, that's the problem that we run into. We're more than willing to work with a driller. We've had some good luck with some of the drillers in the township, but until you have a definite spot you want to go, you can't just make the whole northern half of the township the overlay district of drilling. You've got residential areas, business interchange areas. I mean, where do you draw the line? I'm going to ask Mr. Grossman just to explain, I mean, our legal bounds as far as compatible uses in the zoning district.
Yeah, I mean, the purpose of zoning, as you're aware, is separation of use for the protection of property. And though I wasn't eminently involved in that, the township worked with the GIS consultant, and there are things that do not show up on that map that show up on air photos, such as house locations, building locations, that I suspect had an impact upon the development of those district boundaries.
Well, my point is that just a plain view of the map, there are more arbitrary aspects to the overlay district than it's a shoot fish in a barrel. So,
But you don't know that unless you compare that to an aerial photograph.
well, I mean, I can compare it to the size of the zoning lots and the existing lots. Why stop this here instead of zoning this whole lot right here? What makes this zoning, these are all different zoning districts.
Well, the problem is that's what you requested a year ago, and that's I've explained it, that's why it's there. That's why the Kendall property is done the way it is, because that's where we thought you wanted to be. That's where you requested, so we put it exactly where you requested.
Well, it sounds like there was a miscommunication, so I would ask again that you table into consideration so we can have further discussions about this before you make a decision without full understanding of the issues.
We have all your,
I do have a question. Go ahead. I do have a question, and I've got this up before. Why is it only in Robinson Township we have so many problems with the drilling process? You go to the neighboring townships, they don't have all these problems.
we haven't had, up until recently, we've had no problems with the drilling. You know how many well pads we've approved?
I know, you brought that up before, but there were so many that were denied also.
No.
But the other surrounding townships have no problem, they move forward.
There were not so many, there were two.
There were two.
We've gone through this
Well, okay,
over
two.
and over and over.
Two.
You know what the representative from the midstream company said to me after we finished approving all the drilling process? He really appreciates how professional we were, and he appreciates working with us.
So you mean the other townships aren't professional?
I don't know what the other townships do. You're making an accusation that Robinson Township is somehow difficult to work in. And I say this to you. We make them follow the rules. long as the rules are followed, there's no problems in this township. None.
And Mr. Campbell, I think you know as well, I mean, South Fayette, Cecil, Robinson, and Mount Pleasant are all in court with the industry. You know, over one site or another, they're all in litigation with industry. So it's just, you know, you have to protect the township as a
I
whole.
understand that. We have Smith neighboring, we have Finley neighboring, and everything's moving forward. It's all.
Smith has one cat, or Finley has what, one cat?
They've went past so far, and more coming out.
One cat? We've approved 3 pads for range resources in one night.
Yeah, that's in the past.
Yeah.
We need to move forward.
Understand.
Right?
What about Chevron? We have a good working relationship with Chevron. They come in before us with different things. There's no problem with Chevron. Rice Energy, I understand
That's
Rice
not-
Energy.
We just need to move forward.
Well, let me say that one of the big problems Robinson has, and you don't see it as much in some of the other townships, we have multiple drillers in the township. If we had one driller, I don't think we'd be having this conversation, because there would be no access problems whatsoever. The problem is we've got multiple drillers. You've got one driller, say Chevron, in the northern portion of the township, and then people on the other side want range to drill on the other side. So that's where we run into a problem, not with the driller. It's the multiple drillers.
Mrs. Valentina?
I guess it's mainly for you, John.
Okay.
You mentioned before that the Supreme Court decision may affect
Yeah.
this overlay district. Do you have any time frame for when that decision might be made?
I wish I did. We argued last October, and in August, the state asked for re-argument, and the Supreme Court is weighing that decision as well as the ultimate decision. Unfortunately, there really isn't a timetable for the court to rule. If the court would come back and find against us and overrule the Commonwealth Court, then the overlay district would go away.
Absolutely.
Yeah, you would just be able to drill everywhere, and there'd be nothing to stop anybody from anything, and that may be fine, if that's what the township wants. If the court comes back, they may also come back and look at and really develop compatibility, because that was the constitutional basis why the Commonwealth Court struck down the law that you can pretty much drill anywhere, because it wasn't compatible with all your uses. Because the board also has to look at your tax base and has to make sure that your tax base is maintained. And so it's a difficult balance, and you see all the comments back and forth. But to your question, Ms. Valentina, I wish I knew, and I don't know.
I think that one thing you should keep in mind is if the Supreme Court affirms, is that the proper word?
Affirms the Commonwealth.
Affirms the Commonwealth Court, and we have it as conditional use in this township, we can be in trouble, because the compatible use law still applies. And under our current zoning ordinance, having a heavy industrial use or an industrial use or heavy commercial, whatever way they want to define it, technically, you're pushing the envelope of the law. So if they come back and say the Commonwealth Court decision stands, or they add to it, and we're in this township of conditional use, there's going to be a lot of people that can't do anything. You're not going to be able to drill. That's the idea behind the overlay district. That's how we can put those uses everywhere. And I have absolutely no problem looking at areas that they want to look at, areas that Mr. Temple wants to add on to that. I think that's not an issue. But that takes a little cooperation. And we've had some cooperation, and at other times we've had nothing from the industry. Are there any other public comments? Not yet.
All right, guys. My name's Amanda Kendall. I live at 1620 Valley View Road. I have one thing I want to say first, and then I want to read something. So I think that, first of all, I think we do need a new ordinance, because you have to have a rocket science degree to understand the first one. But I think that the ordinance that you guys are proposing is garbage. I apologize, but that's how I feel. And I would like to know how much of the residents' taxpayers' dollars did you guys, as the board, spend on advertising and the solicitor's fees for this amended zoning ordinance and the new zoning districts that clearly, as the residents are here, and we have 250 signatures, which might only be 13% of the residents in this township, but how many residents vote in this township? 400? 450, something like that. So that's not even half, not even close to half, that's not even 25%. But what I really want to know is how much you guys spend on this ordinance.
We got a grant to do the ordinance.
You got a grant.
We got a grant to do the ordinance. And I don't know what the advertising costs.
And I don't know what my fees are here somewhere, we can look at that. I think there's a right to know from Mr. Campbell about that, so I don't have him with me looking at it.
Are we going to go over all this in the after meeting?
You can, Mr. Campbell, I think, requested it, so he'll be good.
Yeah, it's not that much.
And I think I answered this gentleman's question about the grant amount, but it's a matter of public record too, and it flows out for the grants there. So you can find out.
Did you get it?
Somebody asked,
Claire Sanders.
Loretta Kendall. I have a question. You mentioned before that you got a different consultant to do the overlay?
that was a mapping consultant.
Right, the mapping
Yeah.
consultant. You had a different one?
Yeah.
What was his cost?
I think it was that part of the grant? I don't remember.
You don't know.
I don't know.
I can look, I don't know.
The actual maps are fairly inexpensive to do.
Yeah, but you said about the overlay
Yes.
was by a different consultant. You didn't use this gentleman here who was under the grant. So why did you go to a different person?
From the beginning, I worked on preparation of the plan, but from the beginning, the township worked with the GIS consultant because the mapping is actually in air photos and databases, so the township from the beginning under the grant has always worked with another company on mapping.
But the overlay portion is part of the ordinance.
Yes, it is, as is the zoning map.
But I didn't see in the comprehensive plan it talked about,
The other company did the mapping for the comprehensive plan too,
but the,
through coordination with
but who is
myself.
that?
But who is it?
GIS, I thought we said?
He works with.
Yeah, it's GCCA, it's a little mapping company in New Wilmington, Pennsylvania.
But also a comprehensive plan is just that, it's a plan.
Yeah,
So the ordinance that and all this that we're talking about tonight is the implementation.
that's correct.
Right.
Yes.
But an implementation also needs to have an opportunity for people to do their concerns, what their opinions are. So, as you heard tonight, most of the people, this is the first time,
That we're seeing this.
and that it should be tabled for that reason.
And they can
Because it's a
read
plan
what's understanding.
that you're trying to implement.
Any other public
Did I
comment?
answer your question?
Yeah.
Okay.
Stephen Duran, 216 Campbell Road. Okay. So what I've heard so far, I heard a comment. If you were having these discussions with the solicitor, what public meeting was it brought up at? You said you had discussions about this ordinance and overlays. What meetings were they brought up at? I don't recall.
You know what, I've had some discussions with the manager, some discussions in executive session.
Isn't an executive session just for personnel? Isn't that a violation of sunshine?
Any individual supervisor can call the solicitor and talk to them.
I understand.
That doesn't have to be done.
Yeah, so once it was drafted, I did field some phone calls, some questions. And I think my time will probably reflect what I did.
Okay.
And I know Mr. Campbell. So,
And the other comment I have is, so far what I've heard from the board tonight was, I assume, I'll have to get back to you, I don't know, we need time, we're not sure, it's drafted poorly, I don't remember. What part of that shows, I mean, that right there should tell you this needs tabled. I mean,
Well, nobody's sitting there arguing that point with you, but let me make another point.
okay.
The ordinance that we currently have is so bad that for the last 5 or 6 years, we have done nothing but fix that ordinance up until, was that a month ago, Mike? People were trying to build a house and they couldn't do it in that preservation area because there was a mistake in the ordinance. The most difficult part of doing the ordinance is the last year or so when we're going through, looking for all the problems that may come up and fixing those things. The actual ordinance itself went pretty quick, but the old ordinance is so full of mistakes that I can tell you, we have fixed so many things in that ordinance that it's to the point where I don't know what to do with the ordinance.
Same with this. This has so many Band-Aids, so many holes, so many loopholes.
This ordinance may need some fixing.
No, a lot.
But it's 1,000 times better than what we've got.
I think it's 1,000 times more restrictive, and it's you guys imposing your will on a new board. This is ridiculous, Brian.
I just explained to you that somebody came in and could not build a house along Old Steubenville Pike because of the old ordinance. It was a clear mistake in the old ordinance.
This is creating more headaches for our township.
Yeah, Brian, the problem I have with that comment was, that was a comment you made 6 years ago. The problem I have is it took you 6 years to change that ordinance, and on your way out, you're going to change it. Now, 6 years ago, I had the honor of serving in this township for 17 years. But I'm going to say about maybe 10 years ago, some people came into this township from outside under the guise of environmental integrity. They call themselves the Environmental Integrity Project. They're going to help this bucolic, backwards neighborhood deal with these big power companies and show them how to get along with the power companies and how to protect us. So the township didn't listen to the people who lived there all their lives. They listened to the people who came from the EIP. Well, in my opinion, that EIP didn't stand for environmental integrity. It stood for energy infrastructure parasites. They made their money, they made their living off of getting standing, filing frivolous lawsuits, putting up law blocks, making protests, and I've seen it happen. So what happens is this township doesn't progress. I'll give you an analogy. One of the farmers came to me and said, I had to put a cow down because the cow was walking in circles. It must have had a parasite in the brain. I think what's happened in this township is there's some parasites have lodged themselves in this township and are stopping us from progressing. Now we need to move on. You said you successfully gave 5 wells in this township under the old ordinance. Why can't we keep doing it under the old ordinance? What is the tone of this new ordinance? What is its purpose? What is its real purpose? Is it to punish certain people? Is it to hold back the energy companies? I think it's time to get rid of the parasite. In this, the words of Jack Nicholson, this township needs a good enema. Amen.
Please, let's keep it brief, because we really
Sean Graham, 232 Robinson Church Road. Basically, tonight I can sum up in a couple of words. The residents have spoken. We are fed up. We are disappointed by vain, big-headed representation. The residents have spoken. Never before has there been a clear message sent. Never before in this township has there been such a lopsided victory. How would you feel to be remembered like that? We have spoken. In the primary and general election, there wasn't even 50 votes. We are bored of the stale caterwauling by environmental parasites who think they are looking out for everyone's best interest. They don't even know how much they have set back this township and hurt everyone, including themselves and their children. We are finished with the chest beating and being represented like a perennial losing football team. The residents have spoken. We are not in favor of the policies of this lame duck board. The residents were definitely not in favor of the beautification sign painting project by the class of 2006, and we are not in favor of the zoning changes. To the incoming representatives, I hope you remember why you were elected for this position. Our current reps do not. One of our soon-to-be representatives is a veteran and an Eagle Scout. He knows how to serve his community. He is one of 15+ Eagle Scouts in his extended family. He can count on his family. 15+ Eagle Scouts. That is an unprecedented number. I am proud to be one of those Eagle Scouts. Our community teaches our children to be stewards of the earth, not servants. So we ask our supervisors, finish your term. Return to your mediocre lifestyle and give the residents back their township. We are disgusted by the term and team of aging second raters. I thought of 2 quotes that might sum this up. The sort of quote like Dylan Thomas would say, Do go gentle into that good night, or by lyricist Vincent Neil Wharton. Don't go away, Matt. Just go away. Thank you.
I just wanted to ask Mr. Smith for clarification on what deliberations you had on the zoning ordinance in executive session.
Just we went back here in executive session, we talked about some of the comments and whether or not the board should consider taking additional information. That was it. So that was the basis for a quick executive session, which you'll announce at the meeting that's coming up here in the next minute. That's enough.
Are there any public comments on the oil and gas order? If not, the motion to close the meeting. Is there a second? Mr. Rogers?
Yes.
Mr. Love? I vote yes.
You don't have to take it. You want it?
We'll see what the meeting is.
Still at the school? I haven't seen you since high school. I haven't seen you since high school. See, now you're home.
Okay, guys, we're gonna start. Sorry, it's late. I'm ready for bed.
Don't be afraid to use it.
I wasn't.
Meeting will come to order. This is the November 18th, 2013 Robinson Township Supervisors meeting. Would you please rise for the pledge of allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God,
Indivisible, with liberty and justice for all.
First item on the agenda is public comments on agenda items. And we have the gift cards for the employees for Thanksgiving and Christmas, and also the advertising for the proposed budget for the December meeting. Any public comments on those two items?
Yeah, this is not to be funny, but is there any money left to buy gift cards for the...
Well, Mr. Campbell, to be honest, we have more money in our general fund this year than we did this time last year. If you have any other questions, just feel free to ask. Moving on to approval of meeting minutes. Are there any questions from the board regarding the October 14th meeting? If not, is there a motion to approve the meeting minutes from the supervisors meeting on October 14th, 2013?
Also moved.
Is there a second? Mr. Brozens?
Yes.
Mr. Love? My vote is yes, motion carries. Payment of bills. Any question on the bill payable list? Is there a motion to pay all the listed bills?
Also
Is there a second? Mr. Burns?
yes.
Mr. Love? My vote is yes, motion carries. Treasurer's report.
The general fund, we have $76,038.26. Liquid fuels, $14,076.78. In the light fund, we have $4,095.05. Capital improvement fund is $16,464.97. Act 13 impact fee money is $523.07. Total monies received during the month of October is $50,847.79.
Any questions from the board on the treasurer's report?
No.
Is there a motion to accept the treasurer's report?
Also moved.
And I'll second it. Mr. Brozens?
Yes.
Mr. Love?
Yes.
My vote is yes, motion carries. Secretary's report.
from Range Resources in regards to the Dawn